Get the record. All right. So I'm Angela Moonan. I have with me today, of course, attorney Joe Stanley. Welcome, Joe.
Hello, Angela.
And attorney Megan Fallon, who is a dedicated attorney along with her team as part of Stanley Law to workers' compensation and Social Security disability. Welcome, Megan.
Thank you. Hello.
Hello. Good morning. All right. So we are talking today construction, labor law, as well as workers' compensation. They're very intricately related, and Joe and Megan and their teams devote themselves to a great deal of experience and work in this arena. And we are going to be taking your questions live today. This session is being recorded, but we want to answer any questions you have. So I am monitoring the Stanley Law Office's Facebook page. For any questions you may have, certainly feel free to fire them away, and when we can work them in, we'll get some answers for you. You can also refer to, in the future, the Joe Stanley Stanley Law YouTube channel. This will also be shared via Twitter and on Instagram. You can find us in all those places you find your social media. So with that, I'm going to pass the baton to Joe, and Joe's going to kick things off regarding construction, and then eventually we'll turn it over to Megan to talk specifically workers' comp. Joe, take it away.
Thank you, Angela. Good morning, everybody. Welcome to this presentation. This is a topic that we have discussed in the past, and we are discussing it now for a lot of reasons, because it's the construction season, and there's going to be a lot of construction in our upstate New York area, particularly in the Route 81 corridor. There's a massive project starting there, but there's lots of construction ongoing, and it's something that we all are involved with tangentially, but the people actually doing the work are subject to having special protections. And we're not talking about the protections in terms of the vehicle and traffic law right now, which requires you to follow and watch where you're going and slow down and follow those rules when you are going through construction sites on highways. Those things you should be aware of, pay attention. Those are big fines and big tickets if you violate them. And I believe New York is either doing, or they're talking about using cameras to enforce construction zone safety. But that's not why we're here. Although I can tell you, we have had construction clients that have been injured by people not following the rules on road safety. And you don't want to be a driver that hits somebody doing construction work. And they don't want you hitting them, obviously. And they are unprotected and are at severe risk if you're not paying attention. But let's move on to the actual rules that protect the workers engaged in doing the work. We call them labor law as lawyers here. There are construction work site safety statutes. The first one is section 240. And this deals with elevation related work involving the erection, demolition, repairing, altering, painting, cleaning, or pointing of a building or structure. Now, those are all great words. And this statute broadly encompasses not just construction, but all those other activities that I just described. So it may apply to you in doing your work in a non-traditional construction type setting. So that is important. When you get hurt on the job, that you go to Megan, and we're going to talk about it. And when she hears the facts of your case, she sends them to me or to someone else, to Rob here in the office, to evaluate whether or not this statute covers you, because it is not necessarily obvious what these terms and provisions mean. Okay. There is enough legislative history to say what was meant, when these statutes were passed, but over the years, the courts have had thousands and thousands of decisions interpreting what this law says, many of them inconsistent, incoherent, conflicting, such that from year to year or from even section of the state, exactly who is protected and how they are protected is subject to change. Now, what does that mean? Well, that means that if you're involved in one of these situations, you need to have a lawyer help you out, because it is some situation where it is not possible for a layperson. And it's a lot of times lawyers can't agree, let alone what lay people think about what are these safety statutes apply and who they apply to. All right. The one thing we can talk about, though, is the owners of 1 and 2 family dwellings who contract for but do not direct or control the work are exempt from this provision and the subsequent provision we're going to talk about. What does that mean if you own a house or you own a 2-family house? And you are not subject to the requirements of this law, but it has to be a 1 or 2 family home, and it actually has to be a residential dwelling. There are exceptions, and there are situations, by the way, that we're not going to talk about here. When you are engaging in construction, whether you're a homeowner or a business owner, the legal liability should always be taken into consideration when you are signing contracts with contractors who are doing work on your property, whether it's a residential property or a commercial property. And again, this is that's not a subject matter for what we are talking about here today. We could spend probably an hour talking about insurance coverages and how it applies to this kind of legal liability. But we're not going to. We may do that in a subsequent webinar, but that gets very complicated. Suffice it to say that when you're involved in construction work of any kind of situation, you should make sure that everybody has the appropriate insurance and that the appropriate legal documents have been signed so that everybody understands their legal responsibilities at the onset of a contract. And that's not just for liability purposes if somebody gets hurt. That's so that everybody understands what the scope of the work is, what the work is expected to be performed. And if there's a dispute, it is in writing that then can be used by the trier of fact, usually the judge, to determine what violations, if any, occurred. Okay. Back to 240. So it's essentially this provision applies to the kind of activities we talked about, but it requires you to be working at an elevated related risk. That means if you're on a ladder, you're on a roof, obvious height risk, but there are also many of these risks that are not obvious in the sense that they are gravity related risk, but they are covered by the statute. And there are others that you would think were gravity related risk that are not covered by the statute. And again, that goes back to the point I made. Sometimes they're conflicting, confusing, and not necessarily logical. All right. And all of these become important is because when you are hurt on an elevated related risk situation that is covered, you are entitled to absolute liability under this statute, meaning that your comparative negligence, your actions in causing the injury are not considered. And that's a big deal when you go to court. That's why these statutes are rigorously defended by the insurance companies and the companies that they insure, because they, from the inception, understand what is covered and what's not, and they try to craft a factual scenario that eliminates their legal liability. Again, if you are injured on a construction type accident, it is a situation where you really should get legal advice as soon as possible if you have sustained any type of significant injury, because establishing the facts are critically important in this provision and the next two provisions we're going to talk about. It's all about investigation, investigation, investigation. And many times people's recollections, people's alliances, so to speak, meaning who they're working for, who they're not working for, whether they're inclined to be helpful or not, change dramatically over time. All right. So that's 240, elevation related risk statute. Section 241(6) is a broad statute that covers all construction, excavation, and demolition work. And this is a narrower definition than the kind of work that is covered by 240, which I already talked about. And this is a general workplace safety statute. All right. And this is not an absolute liability statute. This is not like section 240. 241(6) is a statute that establishes standards for work safety in construction, excavation, and demolition. And if a violation of those work standards is found, then the owners and general contractors are legally responsible for those violations, but the worker's comparative fault can be considered in determining the amount of your compensation. How's that for a mouthful? Again, this statute says something, doesn't say really what, doesn't say what the standards are, by the way. It says that they should be done safely. In order for this statute to be effective, there has to be a violation of a rule and regulation promulgated by the state of New York back in the 1970s, the Code of Industrial Rules and Regulations, which I usually have one of those on my desk, but I gave it away to somebody. And there has to be specific rule, not general. All of this gets to be considerably confusing and problematic. These are rules that were put in place in the 1970s and have not been amended or changed since then, because OSHA superseded them for everything except legal liability under this statute and under the subsequent statute. What does that mean? It means it's a full employment for lawyers again. If you're involved in construction, excavation, or demolition work and you are hurt, again, you need to consult a lawyer to find out what your rights are. In the first place, of course, will be, as Megan's going to tell you, is you're going to obviously want to file a workers' compensation claim, but simultaneous with that, it is critically important in these kind of cases, just like in section 240, to investigate, investigate, and investigate to establish what the facts are or were, and make a determination if you are covered by the rules and regulations that are in place under this statute. And that is not an easy task. Every month, the appellate division issues decisions where the scope of both 240 and 241(6) are argued. Next statute is section 200. Relatively easy. Seems pretty obvious that there's a general duty to protect the health and safety of employees. And the same rules and regulations that applied under 241.6 apply under section 200. Except section 200, unlike sections 240 and 241.6, generally does not impose a non-delegable duty upon owners and general contractors. Now, what does that mean? That means that what is important to you is that in order to have a claim above and beyond workers' compensation under this statute, someone has to actually be directly involved in one way or another in the unsafe condition. And I'm paraphrasing the law. It's not that simple, but that's generally the situation. This is more of a classical negligence situation, like a fall, a trip and fall on a sidewalk or a broken railing. The law under section 200 is similar, but not exactly the same. What the legal parameters are. In other words, you have to find somebody essentially did something wrong and your fault is involved in a comparison of legal liability. So we have 240 and which is an absolute liability statute. 241.6 is not an absolute liability statute, but it, along with section 240, give a non-delegable duty to provide the protections under the statute to the owners and general contractors and their agents, which gives the protection to construction workers far different than almost every other work field, because there are, at least to my knowledge, no other statutes in New York that provide this kind of protection to people injured in a workplace, to non-construction place workers. If you're injured on the job, your legal remedies are workers' compensation. And if someone else other than your employer and your co-employer were negligent in causing your injury, you potentially have a claim against them. There are no general statutes providing specific liability for the people involved in contracting for the work other than in what we're talking about here. And that's very important. It's a big deal because having someone responsible for your injuries above and beyond workers' compensation is a very significant benefit to the workers involved in this dangerous work. As Megan is going to tell you, workers' compensation is limited in time, place, manner. It is a rules about rules environment. If you don't follow this rule, they slap your hand. If you don't follow the rule twice, they might kick you out of the system. And I'm not really even exaggerating. They impose these rules to make it as burdensome and difficult as possible for you to collect workers' comp. And then ultimately, even if you are significantly disabled, unless you are totally disabled, your benefits for lost earnings have a cap. And I'm not going to talk about those. But what it means is that workers' compensation only pays so much. It only pays so much of your lost earnings. It only pays so much. It doesn't pay any for your permanent disability or your long-term pain and suffering. One could argue about section or about scheduling under workers' compensation, but I'll leave that for a different time also. So your benefits that you get under workers' comp are limited. Under these statutes that protect construction workers, you are entitled to sue for all of the legally permissible damages that exist under our system. That means past and future lost earnings, past and future medicals, past and future pain and suffering, compensation for permanency and loss of enjoyment of life. And that is a very, very big deal if you suffer a significant life-changing injury on a construction or the work that is covered by these statutes. So that segues now into we already talked about the differences in the three as I went through them. The segue now, Aaron, the most important thing to understand is, okay, you're hurt on a construction site. You should immediately get help, take care of yourself, and because the first and primary is taking care of yourself. But if possible, you or family members should get a hold of an attorney to investigate the facts and circumstances of the accident as soon as possible for both workers' compensation and for any potential legal liability under these statutes. Now, most of the people that come to us under two scenarios. One is people who are hurt on the job. They don't know anything about these statutes. They're hurt on doing construction work and they have a significant injury, and we tell them, okay, you know, you're entitled to these rights. And they are surprised, but it is a significant benefit to them. The other group of people who come to us are independent contractors, quote unquote. Independent contractors in the construction business are common. Many times they are involved in working on 1 and 2 family homes. They're working for contractors that are really treating them as employees. We have had webinars about this independent contractor versus employee scenario. The statutes protect you as an independent contractor working for a general contractor on a 1 or 2 family home if you are indeed an independent contractor. Working under the table, working as an independent contractor has extreme risk. In fact, a very good percentage of the construction accident cases we take at this office are those kinds of scenarios because they're small, they're not safety focused, and many of the people are put at risk to do very dangerous work with almost no safety devices.
I'm just going through here, Joe, because I'm not sure which, I want to make sure that we're covering what you want.
No, I already covered all of these anyway.
Yeah, that's what
Ultimately, also, if you are a independent contractor, you don't get workers' compensation, as Megan will tell you. You're on your own. And if you're working for a contractor that has no assets and doesn't have any liability insurance, and you really are his employee anyways, you are then stuck in the black hole of the New York State Uninsured Employers Fund, something that maybe Megan will touch on. But if any point that I can make, and I've really just given a general outline here, is that if you're hurt on a construction type work, you need to really talk to a lawyer, get a hold of somebody right away so that all your legal rights are protected. And I know when somebody calls Megan, that's what she does immediately. And now she's going to tell you about what happens with the comp system and how it interplays, because, by the way, she's going to tell you about liens and offsets, because I'm already bored you senseless with about this. Now she will get in with the technical analysis of, okay, you have a compensation claim, and how does it work with when there's an ongoing personal injury claim? Because they work together, and it's important that they're coordinated. That's why we have a dedicated workers' compensation department. It's very important that they all work together so that you can get the best outcomes possible. And with that in mind, I will turn that over to the person who will get you the best outcome possible, Megan.
Thank you. Thank you. Okay, so let me just share my little screen, my slides too, and then I can see if I can connect up with what Joe has just explained. So I guess one thing I'd like to start with just simply is we're basically talking about two different actions arising out of the same accident in most circumstances, right? So someone gets hurt at work, and here we're talking about in a construction situation. You have immediately a workers' compensation claim against your employer, and then you may have one of these negligence-based actions, which is a totally different separate action that Joe just described. So, and in a real simple way, we could say you have a workers' compensation claim against your employer. You may be able to sue someone else for a negligence action, as Joe just described. So let me talk about workers' comp for a second. And the very first thing I'd like to talk about is what Joe just mentioned, and that is whether the issues that come up about whether you're actually covered at all in workers' comp. So New York state law says every employer has to have workers' compensation coverage. So either they have to be self-insured or they have to have an insurance policy to cover their employees. They do not have to have, if you're self-employed and you have no employees, you don't have to have insurance coverage on yourself. If you get into one of these construction, if you have a great opportunity to get work through one of these construction opportunities this time of year, you want to make sure that you understand what your relationship is with someone who's hired you. If you understand it to be you are an employee, you may get hurt, and then they are trying to get out of covering you by arguing you are not an employee, you're a subcontractor. So even at the start of your work, you may want to kind of make sure you're clear on who just hired you and what did they hire you as? Did they contract with you to perform a job as a self-employed or as a subcontractor, or did they hire you as an employee? The truth is that ends up being a big legal argument for us, for people that try to disclaim on what we call their employees for workers' comp claims. So anyway, but there can be issues going into the work that you might want to look into. But getting to the workers' compensation coverage under construction injuries. So as I mentioned, workers' compensation claims and labor law actions should be pursued simultaneously. So what does that mean? A lot of times clients will call us and they're thinking they have a negligence action or an action like Joe just described, or they're thinking they have a workers' comp claim. We are going to do this for you when you call, but we do not pursue these. We don't pursue your comp claim first and then talk about your negligence claim down the road. There's important time limits, et cetera. So we want to pursue them both at the same time. When you call, we would evaluate your claim as to whether you have one or the other or both. Just briefly on the statute of limitations with the workers' comp. If you get hurt at work, the first thing you want to do is tell your employer. It's got to be somebody other than a coworker. You got to tell them within 30 days that you're injured or you think you were injured. You have to file a claim with the workers' comp board within 2 years. It's a simple process of filing a 2-page form. We can do it for you, or you would do it. Before I get into what's covered, I just want to say this. We have a lot of issues where, well, actually, I think I'm going to pause. I will pursue this or I will continue because I think I come to it next. So the two things basically that are covered in comp claim are medical bills. 100% of your medical bills are covered for the injuries arising out of a work injury for the rest of your life. You're also paid mileage and travel expenses to and from your doctor visits. Second thing that's covered is lost wages. They set your average weekly wage for 1 year prior to the date of the accident, or there's a couple other formulas if you weren't there that long. If you're totally disabled from all work, not just the work that you were doing, but totally disabled from all work, you are paid 2/3 of your average weekly wage. If you're partial, you're paid a fraction of that. So if you get hurt and you're not able to do the work you've done, but you could in theory do something else, some light work, you're actually partial and you get a fraction of the total. So the payments can get cut down fairly quickly. I want to cover some immediate actions you should take. We're running into this a lot. So as I mentioned, you should tell your employer right away. But secondly, the doctors need to bill the workers' comp insurance company immediately. And there's a practical problem there. You get hurt today and you go to an emergency room or you go to an urgent care. there is no, the comp insurance company may not even know this happened yet, okay? So they haven't set up a file on you, and they haven't, when they set up a file, they assign it a number, which is called their claim number. And the medical billing people are obsessed with the claim number for the comp carrier, okay? They will not bill comp unless you give them the name of the insurance company and the claim number, okay? The sooner you get that, the better. So a friend of mine fell and broke a wrist recently. She called me. We were able to file a claim like immediately. She got hurt on a Friday. She had surgery on Monday. So it's a simple thing where we just get a hold of, we have to find out who the comp insurance company is. Some employers are annoying and won't tell you. We can look that up for you on the the Workers' Comp Board website. Once we have the name of the insurance company, we get a hold of them, make a claim so they know that it happened, and they will immediately set up a file and give you a claim number. Once you get that, the name of the insurance company, the claim number, every doctor you go to, when they say, who do I bill? You say workers' comp. If they say, is it covered? You say yes. You don't say, I don't know yet, because they need to bill the comp carrier in writing immediately, properly, and within the amount of time. So what are the time frames? The medical providers have to bill the comp carrier within 90 days from the end of the month where the treatment took place. If it's outpatient treatment, if it's inpatient treatment, it's 120 days from the end of the month where the treatment took place. So I had a guy call me yesterday. He's got a really serious injury that's been going on for 6 months, and everybody's billing his private health insurance. Not only is that a problem because we can't get those bills paid, it's a problem because now we're going to go back to a doctor who has been billing private health insurance and ask him to clarify that this was actually work related. If it's work related, so it's hard. I mean, he shouldn't be billing private health insurance if it's work related. So we're kind of asking a doctor to state that all the billing he's done so far is fraudulent. So long and short of it is, you want to get it billed properly and on time. So you want to get that claim made right away. And as I mentioned, the two benefits. So I'll move on. So wait a minute, I'm going in the wrong direction. Sorry. So again, as I mentioned, medical bills and lost wages are paid. Joe mentioned earlier that comp is very limited. When they first wrote the comp law, you could get medical coverage for the rest of your life, and you would be paid for the rest of your life if you qualified. So when I first started more than 25 years ago, we had a lot of clients that were paid comp, paid pension from their job, paid Social Security, disability. Even though none of those were very great and they couldn't survive on it, together they could get by. The comp benefits have substantially changed. There's now a cap on how long you can be paid lost wages. So first of all, in every case, permanency has to be determined. If it's a limb injury, your payments stop once the doctors say you're at maximum medical improvement, and they can determine your percentage loss of use of that limb. So if I have a shoulder injury and I'm out of work for 6 months, or let's say I'm out of work for a year, the doctor says I now have 25% loss of use of my arm. Payments stop. There's a determination of what the 25% equals. They subtract what was previously paid. If there's a difference, you get a check. So if it's worth 20,000, you've already been paid 10, they'll pay you 10,000 more, the other 10,000, but no more payments. So if you're out of work, you can't get paid anymore. If it's a neck or back injury, a permanency determination is made, and they look at both your medical and your vocational factors, age, education, work history, and they determine what your permanent level of disability is. That then triggers a cap on how much longer you can get paid. So I've given examples. If you're 75% permanently disabled, you can only get 400 more weeks of comp payments. After the 400 weeks, pay stops. That's 7.69 years. It's just shy of 8 years. If you're 50% disabled, you could get another 300 weeks of comp. 25% is 250. Those are the most common percentages. There's other percentages and caps, but they're roughly, they're graduated within that system. If you're injured so these cap systems started for all injuries after March 13th of 07. All injuries after March 13th of 07 are subject to a cap. If you're injured, but then they've made it even worse as of April of 17. So if you're injured between March of 07 and April of 17, your cap starts to run at the hearing where the judge determines your permanent level of disability. So that means if I'm out of work for 2 years, 3 years, 4 years, before permanency can be determined, which means before I've reached maximum medical improvement. So these are people very seriously disabled, like, you have multiple surgeries. So you're not at maximum medical improvement, say, for 4 or 5 years. Finally, we get to a hearing and they classify you 75% permanently disabled. As long as you were injured before April of 17, the 400-week cap starts to run from that day forward. Okay, so you have 7.5 years more of payments available. But a new limitation is put into effect. If you were injured after April 1st of 2017, your cap starts to run after 130 weeks of payments have been made. That's 2.5 years. So if I have somebody that's getting classified at a hearing 4 years after their injury, or 3.5 years after their injury, and they are classified 75%, the cap is 400 weeks, but the cap has already started to run a year and a half ago. So we might be, we might have already used, say, 75 weeks of that 400-week cap. So long and short of it is, it's getting shorter as time goes on, meaning the period of time the cap will pay you. What I didn't mention is there is no cap if you're classified permanently totally disabled. I think the reason I didn't mention it is I should have listed it there, but for thoroughness, but almost no one is classified permanent total. So if I showed you some of our clients that they will not say are permanent total, you'd just be shocked, right? So, you'll have an 84-year-old guy who has had a back fusion, and they'll say he has some limited ability to work, so he's 50% permanent or 75% permanent. So long and short of it is, if you're permanent total, yes, you'll be paid for the rest of your life. But if you're permanent total in comp, you're one of a very, very rare number of people. So 99% of the people are classified with some form of permanency, and they are subject to a cap, so their payments do not go on forever. So we have people right now that are calling kind of out of their minds because they knew they had a cap, but it was 8 years, right? But now they're 63 or 4 years old and their payments are stopping, and they literally have a real financial problem in terms of how they're going to get by, because they certainly are not any more able to work 8 years after their injury, with less skills, et cetera, today as they were then. So it's a problem. And just briefly now, I'll just cover liens and holidays. So basically, practically speaking, what happens with comp is you get hurt at work, comp starts paying your medical bills, comp starts paying you, you start dealing with us, our department, the workers' compensation department. We help you get your meds paid, we help you get your surgeries authorized, we help you get your paid. In the meantime, the personal injury department of our office may be working on a personal injury action, which is a second action, and they're working that case out. Those cases, unlike comp gets going and starts paying little piecemeal, paying the medical bills, paying you, and fighting all these aspects right away and all along. Joe's personal injury department, when they bring an action for you, it either settles or there's a jury resolution of it one time, right? So there's a one-time valuation of that case. Once it is valued, okay, so comp pays your medical bills and lost wages. The action that Joe's going to bring on your behalf, that also, the value of the case overlaps with comp, because part of what they're claiming is your lost wages and medical bills, right? So the law says you're not allowed to get reimbursed twice for anything. So when Joe goes and gets you money out of this claim, comp gets a lien on those proceeds. Why? Because they say we already paid your lost wages and medical bills to the extent of X dollars. So whatever they have actually paid, meaning whatever the comp insurance company has actually paid as of the date of Joe's settlement, personal injury, they get their money back. Well, they basically get 2/3 of it back. So if they've paid $50,000 in accommodation of medical bills and lost wages as of the day Joe's settling a claim for you for $200,000, the comp carrier has to be paid back out of that money first before you get anything. Once they are paid back and all the other expenses are paid and you get a check, okay, we call that your net proceeds, or the money you actually got out of the case. The comp carrier gets to then go on a holiday for the future money. So that means the holiday refers to, if Joe got you a settlement today, you get a check in the mail for a certain amount of money. And tomorrow you get an MRI of the same injury, and let's say the MRI costs $900. The comp carrier does not have to pay that money because you just got, let's say you got $75,000. The comp carrier by law gets to say, look, we're on holiday. You just got $75,000. So the law thinks part of that money you got is to pay for future medical expenses. So that next medical bill is not paid. Also, if they were owed you, say you're getting $400 a week in lost wage payments, once you get the proceeds from the personal injury action, you don't get that comp money either. Actually, you get a fraction of it. Generally speaking, you get 1/3 of it in most cases. So so, I mean, we certainly can help you with those liens and holidays. They're complicated, but we can explain it to you. But just, it's good to be aware of that. But just in summary, I think what Joe was saying earlier is critical. Comp is very limited in what it covers, and recently has been gutted pretty substantially in terms of your future rights because of the caps that are in play. The medical remains open, but the payments are capped. So it is pretty critical to get advice on whether there is also that negligence action out there or that other action out there for to be pursued, so that you're actually hopefully covered at least to some degree, reflecting what you actually lost. And so those are kind of the basics on comp as it relates to labor law, as far as I can see it. And you're actually muted.
Yeah,
Yeah.
sounds good. And you know, that is so true. By the way, again, this is a brief overline that when it comes to the end of the line about resolving workers' compensation liens and holidays and settlements, it is a convoluted, I'm not sure which is more complex of a process, figuring out whether the labor law regulations or the statutes apply, or all the rigmarole. And I use that word, there's a better word for it, but I can't use it in a webinar, that you have to go through in order to resolve all of the problems that arise, because everybody has their hand out. And one of the problems is if you bill somebody differently than you're supposed to, Medicaid, Medicare, somebody's always got their hand out. So it is incredibly important that the right entity, and only the right entity, pays for your bills, whatever it is, whether it's a car accident, because there's always somebody out there that will have their hand out trying to get their money back from you. And it is never a pretty situation if it's the wrong somebody with their hand out. That's just another pointer. And it's not the way the system is set up. It is a lawyer's full employment act. And believe me, as a lawyer, some of this stuff that we have to do, and I'm sure Megan would say, is incredibly difficult, painful, and hard for the clients to understand what is taking so long, and why haven't I got my money, and why is it this, and why is it that. And sometimes it is, the explanation doesn't make any sense other than that's the way that it is. And so, you know, we can only work within the confines of some of these very convoluted rules, and our goal is to do the best we can. And that's why starting at the beginning helps it frame it and craft it so you get the best result.
Yeah, one thing I'd like to add too, real simply, is literally when people call us, this person I'm thinking of yesterday, he has a really good case, and I am tempted to not even get involved because so much has been billed incorrectly. And so that affects so many things, that not only is it much more stressful for the client for a long time, it literally affects whether it's viable to get going on it in some circumstances.
Did you say build, the way that it's been billed?
Yeah,
Megan?
so this guy's a nice guy who got hurt seriously and just let everything get put on private health insurance. And now I have to go back to his providers who have done a lot. And by the way, if they've done surgery and not put it under comp, you are so prejudiced by the whole system, the judges, everybody. And even it's difficult to get their doctor. I then have to write to their doctor and say, hey, isn't this condition caused by his work, right? So if it's a repetitive injury, that kind of thing, or even an accident, whatever. This doctor who just billed the wrong people, his office did, which really means he did, has now got to say definitively for me that this is all due to the work injury. And then the next question on crossing, once we start taking his testimony, because the carrier will not accept that, is then why did you I won't ask him this, but they will. Why did you build private health insurance? Why did you build?
I get paid more because I get paid more. I get paid more is the answer.
I mean, it's really fraud, right? So I'm then put in a position to try to prove your case based on relying on medical opinions of a doctor who I'm setting up to be accused of fraud, I suppose. So anyway, it's just, and this all comes usually from the nicest claimants, the nicest injured people that are trying not to make waves or bother anybody. So I'm just going to shove my head in the sand, have my private health insurance pay it, and hope I'm fine. And then when they're not fine and they call us, it's a problem. So it's important to just kind of face what it is right when it happens and call right away.
Gee,
So we can help you
Megan, I
get
mean,
those
we've
ones.
never really spent much time on that. Just that aspect alone, like what Joe was saying earlier, we could probably spend an hour on examples and sharing stories of that
Yeah, I mean,
because
we have a client right now that is so injured, fell off a roof, and they cannot get the hospitals that are out of state to bill the comp carrier properly. They just keep sending it to the mother who's ready to have a heart attack. And we send letters over and over trying to get them to bill it correctly. And what they don't understand is they actually are never going to get paid, because if they don't bill it properly, the judge will not make the comp carrier pay them if they're not paid within, they're not billed within 45 days or 120 if it's inpatient. And if they don't attach the medical record to the bill, they will not, they have not billed properly, they won't be paid. And the New York State comp law says the patient's not responsible either. So that entity will not be paid. The problem for the patient is collection agencies don't care, right? They just keep bugging us. We have to keep sending letters saying it's illegal, you're not supposed to be pursuing this, but it's very stressful for the patient. And literally the medical people should be paid, right? So it kills you that you're killing yourself trying to get them paid, themselves paid, right? Properly billing. It's a really simple but very important thing for everybody involved.
so when you see that intake at the doctor's appointment and it says, is this due to a work injury? If
Yeah,
you're not sure and it did happen, like rather than just as you said, burying your head and just say, oh, I'll just try
right.
to take the traditional route on this. If there's even remote possibility that it was, then you
Yes, and that
probably should
it's a
give
good
yourself the
point,
benefit of
Angela,
the
because
doubt.
not only that, it's often because the billing people, there's so much pressure on them. They will say to the client, I'm not, you can't come here unless you have the claim number. If you say it's comp related, you have to have a claim number, we're not billing it, right? So they don't, so they're like, forget it, just put it on my private health insurance. I need treatment, right? So there's real practical, legitimate reasons why people do it. Sometimes it's because they're trying to be nice. Other times it's, I don't know what the hell you're talking about, claim number. I don't know how to get one, so I need the help. Put it on my private, right? And that's okay for like a one visit. But other than that, call us and let me straighten it out. Even if we don't take it, I'll tell you what to do, to clean it up right away. And then it won't harass you for years.
We could do, Joe, we should do like a whole webinar just on what do you do and why it's so important to follow the process right from the
Sometimes it's
beginning.
even because the employer just won't give them the name of the insurance company. And that's something we can look up online in 2 seconds. But you know what I mean? It's very uncomfortable for the employer and
For the
employee.
employee.
Yeah.
Sure, sure. All right, Joe, any other comments or questions? Megan, any other comments or questions before we wrap up for today?
I don't think so.
I don't have anything further.
All right, so thank you all for participating, for coming, watching. Again, this will be uploaded to the Stanley Law Office's YouTube channel. It'll be here for reference on Facebook, of course. It'll be on the Stanley Law website, which is found at stanleylawoffices.com. If you've had a positive experience as a client with Stanley Law, one of your family members has, we encourage you to go on our Google reviews page or Facebook reviews and offer us that review. We're always trying to learn and to get better, but as Joe said, we're also confined by the sometimes very convoluted and complex laws. So certainly if you've got questions or concerns about your case or a family member's case, we encourage you to call also. And that number again is 1-800-608-3333. Joe, you have a new office.
We
You have a new
do.
office in Oneonta. So now we have offices, of course, here at 215 Burnett Avenue in Syracuse. You are doing Zoom, still doing Zoom conversations with clients, correct, Joe? But you're also doing in person.
Yes, of course.
Both. Whatever
Whatever
it takes.
works best. Whatever works best.
Yes. So we can quote unquote come to you, whether that be virtually or otherwise, or one of our offices. The other offices are located in Watertown, Binghamton, of course, Montrose, PA, and Rochester, New York, and now in Oneonta. So you're canvassing the southern tier, Joe. Joe and Stanley Law Office's nonprofit organization, if you're not aware of it, is musicforthemission.org. We're continually working to help those who have a difficult time helping themselves because, as Joe says, but for the grace of God goes any one of us. And it's always a good feeling and giving back and helping your neighbor. So you can visit that at musicforthemission.org. Thank you so much. We'll see you again next month with another helpful and educational topic. You can catch Joe and some of the team at Stanley Law across multiple radio stations throughout the week in many of the markets that we are in. and Bridge Street almost monthly with Channel 9 here in Syracuse. So be well all, take care, stay safe, God bless, and see you next month.
Thank you.
Thank you.